We continue on page 33 of Decoding the Code. This page cautions us to remember that the repetition of defamation also constitutes defamation. Retweeting a defamatory statement is a good example. Even if you retweet someone else's comment, you are just as liable as the author. Clause 3.4 of the Code deals with identifying rape and sexual violence survivors. You will see the World Health Organization's definition of sexual violence on page 34 of Decoding the Code. This clause indicates that victims should not be identified without their consent. The Criminal Procedure Act becomes relevant here. The Act prohibits the identification of minor crime perpetrators or victims. The Press Code, on the other hand, states that minor crime victims may be identified if consent was obtained from the child as well as the responsible adult involved. Because the law is stricter in this respect, it is safer to stick with the Criminal Procedure Act and refrain from identifying minor crime victims or perpetrators. Mr. Retief's guidance here is spot on. He says, when in doubt, consult. When still in doubt, leave out. Clause 4 of the Code is the Protection of Personal Information clause. The definition of personal information has been incorporated into the newest version of the Press Code. See page 36 of Decoding the Code for more. In a nutshell, here's what you must know. Journalists may possess personal information relating to others if this is for the purpose of news gathering. If you have someone else's personal information, ensure that it is stored safely, that it does not get lost, and that it does not end up in the hands of a third party. The POPI Act has not yet taken effect, and regulations relating to the media will be announced as soon as they become available. Clause 5 of the Press Code deals with hate speech and discrimination. Hate speech is present where someone discriminates against another or a group of people based on grounds such as race, gender or sexual orientation, disability or any of the other grounds listed in Clause 5.1 of the Code. Decoding the Code urges journalists to avoid referring to a person's race, gender, sexual orientation or any other similar ground. Those are listed on page 37. This will only be excused if it is strictly relevant and in the public interest. For example, if the police are looking for a 47-year-old white male, and this is a suspect that's on the run and they want to track him down, then it will be in the public interest and strictly relevant to indicate his race and his gender. Although the media may report on hate speech, it should never be endorsed or glamorized. A closely linked topic that will be discussed during this year's editors' conference is the considerations of polarization. If I receive a tip-off relating to hate speech, part of my pre-publishing considerations should include: is this in the public interest, and will reporting on hate speech or on this specific incident benefit the public? Will it cause harm in the form of polarization? Will it incite further hate speech? These are key considerations to be kept in mind when dealing with scoops that involve, for example, alleged racism or sexism. Clause 6 protects our right to advocate our views on controversial topics. Note that this clause does not apply to news reports. It only applies to opinion pieces. This is a very important consideration. So when you write an online opinion piece, please remember to categorize it. The moment you categorize it as news or local news, breaking news, then you cannot use the defense of protected comment or justified opinion piece. You will remember that we dealt with the defamation defense of protected comment in Clause 3. So Clause 6 just as an extension of this requirement. Comment is protected when it is malice-free, when it relates to facts in the public interest, when it expresses an honestly held opinion. And remember, distinguish clearly between fact and opinion. Mark your opinion pieces clearly. Read more on pages 39 to 42 of Decoding the Code. Clause 8 of the Press Code was drafted in the spirit of Section 28.2 of the Constitution, which states the following: a child's best interests are of paramount importance in every matter concerning the child. If there is any chance that your reportage could harm a child, the child should not be interviewed, photographed, or identified. If you feel that doing so may be justified, do not make your final decision without having spoken to the child and his or her parents or guardian. Deciding to identify a child is a decision that must be taken in consultation with your colleagues and those affected. Read more on page 43 of Decoding the Code. Clause 9 of the Press Code deals with violence and graphic contents. In terms of Clause 9.1, the media must exercise care and responsibility when presenting violence and suffering. We should not glamorize violence or unlawful conduct. When reporting on serious injury or death, avoid gross detail and photos of the dead or the dying. We should refrain from publishing explicit sex. When material is upsetting, warn readers about this. In terms of Clause 10 of the Code, headlines, captions, pictures, or videos or audio should reasonably reflect what had happened if it is included in reportage. Manipulating hard news photos, for example, will be unacceptable. Where images have been digitally enhanced, this should be stated. Confidential and anonymous sources feature in Clause 11 of the Press Code. Although the media should protect sources, this protection depends on the source having acted in good faith.